Good evening, everyone, and welcome back. It's been a little while between episodes. It's that silly season. I hope you're all surviving. I'm trying very hard to survive this time of year where everyone wants everything done before Christmas, but it is a great time of year. We have a lot of fun, so I'm sure you're all looking forward to a bit of a break over Christmas, just like we are. So we will be finishing up this episode and coming back to you in the new year after a little break. So today we're talking about the grey areas of renting, and this is really interesting because I tried to pick out a few areas that people might not be aware of, and as I started looking through the legislation I found more and more, so we could talk all day on this subject, but I'll just cover a few topics that you may not be aware of that might help you and guide you through that process. So starting with what's considered fair wear and tear, and this is a big one and a question that we get asked quite commonly naturally from a property owner and also from a vacating tenant, what's considered reasonable. And it's quite often the area where we have the discrepancies and we have to have the discussions and the negotiations around what's considered fair and what's considered damage to the property, whether that be accidental or intentional damage to the property. So I guess as a guide, some of the things that the Tenancy Commissioner, for example, would look for if it was something that they were looking at as a dispute resolution would be the length of tenancy would be the first, how long the tenants have actually resided in the property. The other, and something that often people don't factor into that, are the number of occupants in the property. So if you've got a single occupant in a property versus a family of 5, naturally you need to expect a higher level of wear and tear over that tenancy, even if it's a shorter tenancy. So these are the things that are looked at. And also the original condition of the property, naturally that comes into play, how old the item might have been prior to the tenant moving in and how much depreciation that item has actually had over a period of time. So typically, and I will read out the extract from the renting guide specifically because it is a little bit loose, but it gives you a bit of a guide. So it says, reasonable wear and tear in general terms includes minor marks, scratches and things that deteriorate naturally. So it is a little bit grey and a little bit loose, which is where we come in as property managers. So wear and tear is not reasonable if it's caused by the tenant, even if it's an accident. For example, stains on the carpet and deep scratches on floorboards. So that's the very brief guide that you have in the Renting Tasmania guide. So I think to be fair and reasonable when you're looking at an end of tenancy, they're the sorts of things that you really should be looking at. Number of occupants, length of tenancy, and how old the item might have been prior to moving. So that's a little bit of a guide on what's considered fair wear and tear. The other is if you do have a situation where you do have damage to the property, how do you go about claiming that damage? And again, quite often people are talking compensation. For example, you might have a situation where we have a stain on carpet that might be 5 to 10 years old. How do you go about, I guess, compensating the property owner for that damage if the stain was not pre-existing? So these are the areas that are grey and they require some negotiation between the owner and the tenant, and usually the property manager is in the middle of that negotiation, which can be tricky. So the thing that you need to be mindful of, and what we are mindful of when we're dealing with that negotiation, is the owner needs to be aware if it does end up with the Tenancy Commissioner, because we're not able to resolve that with the tenant directly, the Tenancy Commissioner will require us to provide proof of loss. So in that situation, if you were penalising the tenant compensation, say $100 for the stain on the carpet, you haven't actually been able to prove that there's been actual financial loss with an invoice. And that's what they will require, either a quote with a work order to proceed to replace the carpet, and then of course you can talk about what loss has been attributed to that damage, or you would need a tax invoice to provide the Tenancy Commissioner to substantiate that loss. So it's not as easy as saying, well, I would like $200 for that stain on the carpet. So you can see where it does get quite complex in some situations, and obviously that's how we would look at that situation. The other is who's responsible for garden maintenance. This is quite a common topic once again, and it is an area that we sort of negotiate early days with the owner and talk to them about what the tenants are responsible for versus what they really need to be taking care of as part of maintaining the property. So I guess as a guide, what you'll find is if we always think ahead. We think, what's going to happen if this ends up with the Tenancy Commissioner? What decision are they going to make based on their guidelines of how they determine these matters? And the guideline for the Tenancy Commissioner is essentially the tenant's responsible for lawn maintenance, edges, general weeding of the property. Anything outside of that, such as pruning, tree trimming, specialist gardening like pruning of roses, those sorts of things, generally will fall back onto the owner as being responsible for those items, because you can imagine that there are obviously very different size yards that we're dealing with. Some are more substantial than others, and some tenants are actually not, qualified enough to know when they need to be trimming things back. So it does get quite complex. In saying that, some tenants love maintaining their garden and they'll treat it as their own. So we're certainly really happy for them to do that. It's just a guide for you to understand where the boundaries are, I guess, so to speak. The next is what happens when the lease is coming up for expiry and the tenant hasn't negotiated a lease renewal. And this is a really tricky one. As property managers with lease expiries, we're generally having that conversation around 70 to 80 days in advance. So that's pretty early prior to the lease expiry. But the reason we do that is because the owner is required to give 42 days notice to end the tenancy. The tenant, however, and this is a little bit of a misconception, isn't required to give notice. So what that means is there's a lease start date and there is a lease end date. The lease end date is technically when the tenant is due to vacate the property, unless there's a renewal negotiated in between that. So what I'm saying is that the tenant is not required by law to give, and what most people think they are required to give is 14 days notice. In actual fact, that's not legislated. But what we say to a tenant is, that's correct, you don't have to provide that notice. However, because the owner does need to give you 42 days notice to end the tenancy, if that's what they choose to do, they will require an answer from you within that time frame also, in order to know, I guess, when the lease is going to expire and how they can plan to relet the property if they need to. So once again, it's a negotiation, and it's something that generally you need to be aware of, because I know that even a lot of property managers think that the tenant is required to give 14 days notice. So I think have those discussions and explain to the tenant the benefit of them securing a new fixed term tenancy, because it is also for their security that they renew the tenancy in advance. So what happens if the tenancy is not renewed? We couldn't negotiate a renewal and the owner didn't necessarily want to issue a notice to vacate to the tenant. So we get to the end of the lease. At the expiry of the tenancy, the following day, the tenancy automatically becomes a tenancy of a non-fixed term. So a non-fixed term agreement has some different rules. It still means that the tenant is bound by and obligated by the original conditions of the tenancy agreement. However, there's not a fixed period. So the rules then change, where the tenant is required, if they choose to vacate the property, to give 14 days notice. So this is after the lease is actually expired. The tenant's required to give 14 days notice, and the owner is still required to give their 42 days notice for vacant possession of the property. The other thing is, and a lot of owners are not aware, that once it rolls over onto a non-fixed term, the rules change around the reasons why you can ask a tenant to vacate the property. It can't simply be because you would like possession of the property. It needs to be because you're using the property for another purpose, or you're moving in a family member, or you're selling the property. So using the property for another purpose might be that you've decided to short-term lease the property fully furnished by Airbnb, for example. The other is substantial renovations that will impact the tenancy. That's another reason why you can end a non-fixed term agreement. So the rules do change. I personally don't ever like to see a non-fixed term agreement, because I like to have that security of tenure for the owner, but also for the tenant, so that we don't have those issues relating to a non-fixed term agreement. That's quite commonly made by not only property owners but also property managers is understanding notice periods. So a notice period relates to when you're issuing a notice to a tenant, such as a notice to vacate at the end of the tenancy. You might be looking to sell the property, you might be looking to move into the property, and you need to issue a notice. The understanding of a notice is that you're required to give a certain amount of time. So usually for an owner, that's 42 days notice. What a lot of people don't understand is that it needs to be clear days. So clear days mean that you don't include the first day of that notice period and you don't include the last day of that notice period. So when you're issuing 42 days, always include 44 days so that you're covering those two end dates, because that is what's required in a notice period. If you get that wrong and the notice to vacate is challenged or the tenant doesn't vacate and it ends up in a court situation, you can actually have the notice void simply because you haven't included those days around the notice period. So be really careful of that. So that's my final tip, but I will be posting some more information for you over the holidays on our page. So we'll keep that up to date. Look, I just hope you all have a wonderful Christmas and keep safe and enjoy the holidays. I certainly will, and we'll see you next year.